by IQAC Cell and IPR Cell in collaboration with Research and Development ICFAI University Tripura. In today's rapidly evolving world, intellectual property is the backbone of innovation, research, and creativity. Through today's program, we aim to deepen our understanding how IPR protects and promotes the valuable assets. Today's session aims to enhance our understanding of importance of IPR in academia, innovation, and industry, a topic that is becoming increasingly relevant in our interconnected world. To begin our program, I request to give a warm round of applause. We welcome our dignitaries to the dais. Professor Dr. Dhananjay Datta Sir, Dean Research and Development, IUT, serving as the moderator of today's program. Dr. Devabhrata Roy Sir, Associate Professor, Faculty of Law, ICFAI University, who will be speaking on Patent Law and Design Act. Dr. Divya Assistant Professor of Faculty of Law, who will be speaking on copyright law. We extend our heartfelt welcome to all of you. Sir, please take your seat on the dais.
And good afternoon to everybody, those who are present online and offline. Today we are IPR to help all the educators and the students, research scholars, so that they can come up with their intellectual property what they are having. Actually, see, IPR simply means to, giving a person exclusive right to use his or her creation in his or her name for several years. So basically, see, young minds are very affluent, and creation may comes. Moreover, for the research scholars, like from PhD, there may be a possibility of having one patent, and this is basically, as per UGC guideline also, this is not a compulsory thing, but having patent from a research work, it's a very novel thought process. So with this effort, we are nurturing the IPR session so that all the students, those who are pursuing their education in UG, PG level, even PhD scholars, to have some patent, design, then copyright in their name. See, patents have IPR have several categories. So today also things patent, then copyright and design. So, like, hopefully this session will be very informative. First part will be covered by Dr. Devabhrata Roy, and second part will be covered by Dr. Deepak Pathak sir. And in between there will be interaction also, and whatever the questions the audience are having, we'll discuss after these two presentations. And I expect that presenter will present that, like, in patent, what is patent, how many types of patents are there, then in what areas patents are possible, okay, and what to do if anyone wants to have patent, okay, all these kind of things. So I will not take so much of time, and with this I invite Dr. Devabhrata Roy to present his part.
Good evening to one and all present here. Respected Dean Research and Development, Dr. Dhananjay Datta sir, my esteemed colleagues, the participants who are present today, both online and offline. So today we will have some discussion and interaction on intellectual property rights. So basically, it is an awareness program on intellectual property rights that we have organized today, and I hope me and my colleague Dr. Pathak would be able to share something which will be beneficial for you. So friends, today when we talk about intellectual property rights, basically in our day-to-day activities, whatever we do, intellectual property in this way or that way it is connected with our day-to-day life. Starting from the morning when we wake up and we start our day. From that point, our breakfast, our lunch, our dinner, our office activities, whatever we do, everywhere intellectual property rights in this way or that way it is connected. And why I'm saying so, during the discussion or after the discussion, after the presentation also, you can ask me a question, I will elaborate. So friends, so in this presentation, actually me and my colleague, we would be covering three different aspects. I would be focusing on patent law and practice, and my colleague would be focusing on copyright and design. So the concept of intellectual property, to come into that before, let us have a look on the concept of property. What are the properties we are having? We are having tangible properties and intangible properties. When we talk about tangible properties, these are some illustrations I have already given you. So that is not our focus point today. When we talk about intangible properties, here the question as to intellectual property comes into existence. So properties we are having patent, copyright,
33
design,
cookies.
and so on. So why these properties are called as intangible properties or intangible assets? Because these are the creation of our mind, human mind. These are the creation of our human mind, and these are protected by some statute. These properties do not have any physical existence, but you can enjoy it, you can exploit it, and you can utilize it. So you can have a look on the classification of intellectual properties that we have. We have patent, trademark, industrial design, plant varieties, copyright, geographical indication, layout, and integrated circuit confidential information. So these are the different branches of intellectual property rights. And out of that, today I'll be focusing on patent. So you see, when we talk about intellectual property, as I have already said, it is the creation of your mind. It is something which you have created, which is something new, which is non-obvious, which is having usefulness. Now, why I say so? Because you see, if it is the creation of your mind, it is innovative, then it must not be already in existence within ourselves. It must be something new. And it must not be an obvious way to do something. If it is an obvious way of doing something, then we cannot say that it is the creation of our mind, because it is already available and people are practicing that. In that case, we cannot say it is creative or it is innovative. That is why it must be non-obvious and it must have usefulness or utility, the most important part of intellectual property rights. Whether it is a patent, whether it is a trademark, whether it is a design, whether it is a geographical indication, whatever, it must have usefulness, which means it must have industrial application. Unless you have intellectual property, because you see the government of India is very much clear so far as granting protection and recognizing intellectual property. Because the government, what the government wants, you contribute in your particular discipline, you do something productive, which will contribute towards the economic development of the country. So commercial exploitation is one of the most important aspects of intellectual property. If, say for example, I have developed a design patent, right? For the sake of my patent, but it does not have any industrial application. In that case, you might have a design patent, but it is not contributing towards the economic development of the country. So today or tomorrow, it is going to be stopped. There is a particular concept called revocation of patent, cancellation of patent, and surrender of patent. That things we will discuss in my coming slides. So now I'm coming to my today's topic that I will focus is patent. What is a patent? It is an exclusive right granted to an inventor by the patent office or by the government. It is an exclusive right. Why it is an exclusive right? Because the right belongs to the owner, the creator, who has invented the patent. That is why. And you see, if your right is violated, you have a right to protect it under the Patent Act by bringing an action for infringement. That is why it is termed as an exclusive right. So this right excludes all others to use, make, sell an invention in a specific period of time. So the objective of patent law is to encourage new contribution, new inventions, development of new ideas, creative ideas, so that it can contribute in the development of patent. So it is a monopoly right. Once a patent is granted, it is a monopoly right. And the question is why it is a monopoly right? If it is granted to you, certain statutory rights would be granted to you. You would be able to enjoy those statutory rights. What are those? One of the most important of these rights is right to exploit. You have the commercial right to exploit commercially your invention. You have a right to assign. You have a right to license. So that is why this is a monopoly right which is granted by the patent. So when we talk about patent, there are different classifications of patent. Suppose today or tomorrow you are going to apply for a patent, so then you must understand the different classifications of patent. So the number one is the most important but most difficult to obtain a patent. It is utility patent. Okay, it is utility patent, and in order to have a utility patent, one of the most important criteria is it must have commercial exploitation. It must have some utility, otherwise this patent cannot be granted to you. So, plant patent, that is, generally asexually produced plant varieties. There is another domain, I'm not going to that, that is called protection of plant varieties and fungus rights act. So their particular act deals with protection of plants, but in addition to that, in case of asexually reproduced distinct variety of plants, you are eligible to get a plant patent as well. Design patent. So you see, this is what is the design? Basically, there is the Industrial Design Act which looks after the protection of industrial design. Generally, it deals with the outer look of a particular product, the look you are giving. Suppose the water bottle is having a look which looks like unique. That can be protected under the Industrial Design Act, as well as you may apply for a design patent in this regard. Similarly, say for example, the concept of water bottle you have taken, but you have developed a new design of that water bottle. So you may apply for the grant of a design patent in respect of that. So the industrial design part would be covered by my fellow colleague. So I'm not going in detail with that. So the basic difference between, you see, when we talk about utility patent and design patent. So one of the main differences in case of utility patent, the term of protection is for 20 years. But when we talk about design patent, there is a lesser term of protection, that is 40 years. So this is so far as the classification of patent is concerned. Infringement of patent. So you see, when a patent will be granted to you, right? You can use the term patent or pet plus the patent number which has been granted in respect of your invention. And if a firm or any other individual makes an unauthorized use of your patent without your consent, without your permission, infringement of patent takes place. And whenever infringement of a patent takes place, as I already told you at the beginning of my discussion, that in case of infringement, the Act provides you a remedy. You can bring an action for damages or accounts of profit. So you see, one of the most important aspects so far as my presentation as well as the grant of patent is concerned, to obtain a patent, your invention must have some basic criteria. Your invention must fulfill these three basic elements. Otherwise, a patent shall not be granted. Number one is novelty. At the beginning of my discussion, I said that your invention, it must involve some inventive steps. It must be innovative. It is something new. So new here does not mean that today I'm wearing this shirt, tomorrow I brought another shirt, so I'm wearing it is new. No, this is not. It has to be innovative, which prior to your invention have never existed before. Okay, so this is called novelty. Non-obviousness. Your invention must not involve a step which is obvious, an obvious way to do something. Right? So in your steps that describes your invention, it has to be innovative steps. Like novelty features is there, and like this, when you are describing your invention, you will be describing the steps of your invention. These steps are very much important because your steps, it is not like that the steps you have taken from somebody else. You made some slight changes here and there, and you introduce it in respect of your invention. It's very dangerous. Your application may be rejected on that ground. So that is why you have to use some innovative steps. And as I said, usefulness, utility of a patent. That is the most important aspect of your patent, because even though you see a patent is granted to you, but it is not commercially exploited. It is not used for a certain period of time. So in that case, there is a concept called compulsory licensing. Either a compulsory licensing will take place or revocation of your patent may take place. So now the question is, who can be an applicant so far as a patent is concerned? So here you see, the inventor is the first person who can file an application for the grant of patent, or his assignee. Suppose you are a person who is invented, but you do not know how to file an application. So you can engage an attorney, you can engage an IP practitioner, or you can engage an agent. So such agent, IP practitioner, or the attorney can file the application for and on your behalf. Like for example, the law students who are available here, they might be knowing when a lawyer represents a case, Bhagalatnama is signed. So in that case, the advocate or the attorney represents the case of a client. The same concept apply here. If you are not able to file it, take the assistance of a lawyer, attorney, IP practitioner, or whosoever. Then the legal representative of inventor or first inventors or his assignee. So it means the legal representatives of the inventor is having a right to file. Even the legal representative is not able to do so, so his assignee can also file an application for the grant of patent. So here you see the process of filing an application for the grant of patent. So if you think that I have developed a patent and I want to have a patent, your first job is to go for a patent search. Because you might be thinking that I have developed something new, something innovative, but you never know the thing is already in existence. So how you could come to know that my thing is innovative? So say for example, you have an idea. On the basis of your idea, you make a search. So you'll be able to know whether the thing is already patented, already available in the market, or really your thing is new. So when you come to this conclusion, you have discovered your patent. Now you can file an application for the grant of patent. So far as the process of getting a utility patent is concerned, it is much more rigorous. in comparison with if I talk about a design patent, which is much more simple. So I am just describing here the process for a utility patent. So now, say for example, you come to a conclusion that I have made a patent. So you will file an application for the grant of patent. Now, the application you have to file in form 1. What are the formats that is attached to the schedule of the Patent Act 1970? Out of that, the form 1 is there, which is the format for your application. So in that format, you will file the application, and in form 2, you have to provide the specifications along with other legal documents, fees, and etc. So those process in the later slides I will discuss. Now, once you file that application, your application will be scrutinized and examined, right? If any shortfalls are there, minor shortfalls, you will be notified to make those corrections. But if it is found that your application do not disclose an invention, your application will be rejected. But say for example, after scrutiny, your application has been accepted, the same will be published. What is the purpose of this publication? The same will be published to invite oppositions against the grant of patent. Right? So you see, you are claiming that this is your invention. What is the objective of this publication? You may claim that this is your invention, but the members generally in the public, they might be thinking otherwise. Somebody may think that this is my invention. So that is why it will be published, inviting oppositions. So if oppositions are filed, after that those oppositions will be notified to the applicant. After that, if the it is notified and the applicant will be asked to submit his views before the patent office. So thereafter, the patent office will be conducting a hearing between the person who raised up the objection and the applicant. So after hearing, if the patent office decides that your patent application is genuine and you are eligible to get a patent would be granted to you. And after that, it will be published in the patent journal. Okay, so your name, address, and everything along with the patent number will be displayed in the journal. Jurisdiction of patent officers. In India, basically, the patent offices operate from 4 different locations. These are Kolkata, Chennai, then Bombay, and Delhi. 4 different patent offices for 4 different regions or localities. Depending on the principal place of business of a particular company or of a particular organization, the jurisdiction of the patent office will be decided. So, what is the principal place of business in India? Say, for example, a particular company is having multiple branch offices in India. In that case, you have to see what is the headquarters of that business organization. So that headquarters will be treated as the principal place of business in India. And when you have only one outlet, that outlet will be considered as your principal place of business in India. So on that basis, the jurisdiction of the patent office will be decided, and an application for patent has to be filed in the appropriate patent office, which is having jurisdiction. Say, for example, we are residing in Tripura. So for us, the patent office would be of Kolkata Patent Office, right? So you see the territorial jurisdiction. It has been beautifully explained in this slide. Mumbai office, it is having jurisdiction over certain states. Delhi office, it is having jurisdiction over certain states. Chennai office, it is also having jurisdiction over different states. And the Kolkata office is also having jurisdiction over certain states, and particularly over the northeastern region states. So, types of patent application. There are different types of patent application. So, one we can say is the ordinary patent application we generally file by the individual. Another, when we talk about it, is a convention application, country in which you are claiming as a priority country, which is a member to the Paris Convention, you can file a convention application in respect of that. PCT application is a national phase application. Actually, it is based on the concept of patent cooperation treaty, and on that basis, you can file a national phase application in India. Divisional application is, a further division of application which you have already filed or you are going to file. So there will be a division of that application. And when we talk about patent of addition, this means improvement of an existing patent. So you might have developed an invention, and subsequently you came up with certain improvement in your existing invention. So in respect of that also, you can file an application which is known as patent of addition. So that you can file this patent of addition application also in patent office. So you see the filing of application. Form 1 shall be the format of your patent filing application. Form 2 would be for describing your specifications, right? When you are going to develop an invention, you need to describe the invention, right? So these descriptions are of two kinds. I will explain that. One is provisional specification, another is complete specification. However, the specifications you cannot file in case of convention application or in case of PCT application. The Indian Patent Office has developed a comprehensive e-filing for patents. The link I have shared here. So here, along with the application, the attachments also you can file while going for e-filing under the Indian Patent Office e-filing procedure. So the process of application, I have shown here are the steps: writing about your invention, describing your invention by means of any diagram, drawing, or sketch explaining the invention. Patent search, I have already spoken with you to check whether the invention is patentable subject or not. Patent discovery, then filing of patent application, publication of the application, request for examination. If any objections have come out, answering those objections, clearance of objections. So after all this process, if the patent office is satisfied, you have fulfilled all the criteria or all the requirements for the grant of patent, the patent office will grant a patent in your favor. Coming to specifications. Now, specifications are nothing but a description of your invention, right? So this description can be of two kinds. One is provisional, another is complete specification. So you see, you would be filing a provisional specification when you believe that you can disclose your invention, but your invention has not attained the final stage. You can disclose, but it has not attained the final stage. So then you can disclose your invention through provisional specification in a written format, and you will be submitting it along with your application. Whereas when we talk about complete specification, it is a technological document. It is very important, describing everything in relation to your invention, and most important part is how your patent is going to work, that you need to describe in your complete specification. That is the utility part. What utility you are claiming and how it is going to be performed. That is to be described in your complete specification. So now the question is why there is provisional specification and complete specification. Anyone in this hall who would like to answer this question? Why there is concept of these two specification, provisional specification? Yes.
We submit the provisional specification. It ensures the date of filing, because if we take some more time in the complete specification, then it may be that on the same ground or on the same process, some one other person
Is absolutely correct.
submit the
You see, you are working on an invention, but there is no guarantee that somebody else is also not working on that, right? So, for example, your professional specification is ready, but somebody else is already working on that, and you know within a limited period of time you are going to have the complete specification. So why to wait? Because the date of filing, the date of priority of filing is very important. Whoever is the first applicant, he would be given the preference. So that's why the provisional specification is very important. You are ready with your provisional specification, you describe it, and you file the application. But if you wait for the complete specification, that is, I'm ready with my everything, by this time it may happen somebody along with the provisional specification has filed the application. So in that case, all the hard work you have invested may result in vain. And that's why the concept of provisional specification and complete specification is there. Now, examination and grant of patent. You see why I said utility patent is a rigorous process. Once you file an application within a span of 48 months, 48 months, that means 4 years, you can make a request for examination of your patent application, right? So you see why it is given, because it is an invention, so it requires a time to work on it and develop it. So you see, this 48 months is the maximum period. It is not that you have to file in the 48 months. You may file at any point of time within this 48 months if you believe that my invention is ready, and I can fully describe the utility part of my invention as well. Now, after that, after your request for examination, opposition, and hearing of parties, if the patent office is satisfied that the applicant has fulfilled all the required criteria for the grant of patent, the patent office would grant a patent in your favor. So now we are coming to the next part, that is, once a patent is granted to you, what are your rights as a patentee? Once a patent is granted, you would be called as a patentee. So once a patent is granted, you have become the owner or proprietor of a patent. So once you are the owner or proprietor of a patent, what are the rights and obligations you have? The most important right that for which people try to contribute in the development of patent, right to exploit. If your patent is there, you have the right to commercially exploit it. You may use it, you may apply it. Now, as a patentee, I may have that I'm not going to use it for the purpose of my business. So in that case, I may license it, or I may assign it to somebody else who is interested to work with my patent. Right? So in that case, you are having the right to earn royalty. That is commercial exploitation, utility part of your patent. Now, when I talk about right to surrender, this generally happens at a later stage. Say, for example, we are talking about novelty, newness, that my invention is new. Today it is new, but after 10 years, 20 years, it might be a thing which is available to the public. People are not showing more interest on that. So why to pay the renewal fees again and again? Better to surrender it, because it is not generating royalty for me anymore. So I can exercise my right to surrender and surrender it. In that case, I will save myself from paying the renewal fees to the patent office. Right to sue for infringement. It is one of the most important rights. You see, whenever there is a right in law, we know there is a concept, where there is a right, there is a remedy. So in patent law also, this concept has been introduced. That I have a patent, but if somebody else without my consent, without my authorization is using my patent, then what shall I do? My remedy is to bring an action for infringement, where I can claim damages or accounts of profit before the district judge. You have to bring this action before the district court of your particular district. Limitations. that means obligations, government use of patent. Sometimes you have developed a invention, but it may happen that the government is finding the invention relevant for public purposes, right? So in that case, the government may go for compulsory acquisition of your invention. Ultimately, the government holds the right. So this government use of patent. Now this use is again of two kinds: government use of patent on payment of royalty, government use of patent without payment of royalty. So generally, where the patent office or the government sees that the patentee has invested significant time, energy, and money in the development of the invention, generally the government goes for payment of royalty. On the other hand, where the government finds that no such significant time, money, and energy has been invested by the patentee, so the government may not go for payment of royalty. So it depends again on the discretion of the government. Compulsory licenses in respect of your patent. You have developed it from the date of grant of patent within a span of 3 years. Your patent is not. It is not generating any royalty. So the patent office finds that some member of the public are interested to work with the patent. So in that case, the government may go for granting compulsory licensing because the interested person who is ready to work for commercial exploitation with the patent. Revocation of patent and invention for defense purposes. So you see certain inventions which are very much relevant for the defense of the country. So in those cases also, if the patent office comes to know that your invention is relevant or very much useful for the defense purpose of the country, the patent office will communicate it with the government of India, and immediately the government of India will ask the patent office, you communicate with the patentee not to disclose any information with respect to the invention. The objective is it is not going to be circulated as it is relevant for the purpose of defense of the India, and the government of India and the patent office in coordination with the patentee would decide the fate of the invention. That's it from my end. Now, from your end, the participants, online and offline, if you have any query or if you want to know anything, the floor is open and I'm ready to address your queries, if you please.
From online participant, anyone? You can raise your hand online. Or you can put the question in your chat box. Stop share. Okay, from online, from offline.
So, and first of all, I would like to thank IQAC cell, IPR cell, and research cell of University Tripura for coming up for such a awareness program for the IPR for the research scholars and all academicians. So basically, to start with, copyright. So I'll start. The topic assigned to me is to talk about the copyright and design law. And it is very much relevant to all of us because we are academician, we are dealing in our daily affair, not many things with the copyright. And somehow I'll be looking into the design part of it. So to begin my presentation, first of all, I would like to define what is a copyright. This sign circle within its C is written there. It is you must have seen it everywhere in academic publication or otherwise in so many places in the level of audio recording, video recording, and all such places. So this is the symbol of the copyright, which shows that this work has been protected by the copyright laws, and there is some owner of this work. So if you see the definition given under the law, section 14 of Copyright Act 1957 talks about it. Copyright is a bundle of exclusive right. So when I say bundle of right, it is not a single right, but there are so many rights associated with the copyright, like the right to use, right to exploit, right to come up with a derivative work, any work which is associated with that thing, that particular creation or copyrighted work. Okay, and it is granted to the creator of an original work. I have already highlighted those parts which are important. The work should be original and it is protecting the expression, not the idea. Suppose I want to write about how to go to the moon, and I have written down the entire thing. So that expression, my expression is protected, not the idea of going to the moon. Okay, somebody else can go to the moon, and of course, there will be no protection, no some kind of so no bar for him from using that idea. So if you go to the Copyright Act 1957, it is the governing law for the copyright and allied rules, and it talks there is a automatic protection for the copyrighted work. So the moment a copyright work is created, it will come within the purview of the protection. You need not to go for the its formal registration, although it is available. But the moment you have written down something, you have created a poem, you have written an article, you have come up with anything. Okay, be it a painting, be it a song, be it a notation, humming of a musical tone. So all these things are protected within the moment it got created. But its formal expression is very important. You have to stick to the formal expression of it, not the idea, but the expression is copyrightable. So the next slide. Yes. So work it protects basically the large number of the creative work has been protected by the copyright. So it includes the literary works, which are the books, journals, dissertation, lecture notes, question paper, computer program. All those things subsist the copyright. So whenever you are creating a question paper, it will definitely it has a copyright of yours if you have done a significant amount of work for creating it. Artistic works, charts, diagram, photograph, paintings. I have tried to include the examples which are relevant to us. Okay. So there are other categories of artistic works as well, like painting and sculptures. So all those are protected under the Copyright Act. Musical work, composition, notation, dramatic work, plays, scripts, all those things covers within the copyright work. Suppose you are creating a film, a small reel, anything, it will come within the purview of the copyright. Even sound recordings like lectures, podcast that we are doing in our day-to-day academic activity, all these things do have copyright. And if you look into the rights, rights of the author. So the author do enjoy certain rights. Okay. Yes. So basically, the author enjoys, like I said, it's a bundle of rights. So many rights are associated with the copyright. But basically, I'll be talking about the economic rights, which are to reproduce the work, publish and distribute copies, and perform or communicate the work. So and translate. Translation is also. So these are the economic activity whereby the author or the publisher tries to gain financially. So all these activities are exclusively given within the ambit of the right holder or copyright holder. And also the moral right is very important, because once something is created, once a copyright is created over some creation, then the authorship is it lies with the creator, and nobody can take it. It's like, right of paternity. Like you have created the idea, or the expression has born out of you, so that entire your effort will be recognized by giving you the right of paternity. And subject to object to distortion and mutilation of the work cannot be done. So suppose I have written a poem, nobody else can change any part of it, even if it is not very much suitable. That part is not very much suitable to the entire body. Then also nobody can change it. So these are the moral and paternal rights over the copyright system. Now, duration of copyright for literary, dramatic, musical, and artistic work, lifetime of the author plus 60 years. So copyright protection will subsist for a very longer period. Okay, so till the time author is alive, it will be there, and after his death, his or her death, his heirs can enjoy the royalty over his copyrighted work for coming 60 years. So suppose 2 and 3 people are authored a book together, then how to calculate copyright over it? So suppose if 3 people are have come up with a single copyright, then the last surviving author, and after his death, 60 years. So that is quite a long period. So one can enjoy royalty over his copyrighted work, even after a death of author. Suppose I have published a book, even after my death, my legal heir will getting the royalty for that book for coming 60 years. So it's a substantial period of time for literary, dramatic, musical, and artistic work, for films and sound recording, because not many collaborations are involved into it. So that way it will be very difficult to assign for a this same criteria cannot be followed there. So 60 years from the publication. All right, Indian scenario is that uh, although the Bern Convention and the WIPO Convention talks about the 50 year plus position, but India is giving 60 years protection. Anonymous and pseudonymous work. Suppose somebody is not giving his actual name in a work or writing anonymously, then he can enjoy the copyright work for the 60 years. Now you can ask me a question that how an anonymous person will be given a copyright. So here the copyright will lie with the publisher of the work. So on there he can collect his economic fruits of his work. Now the international aspect, if you look into the international aspect, actually the first convention that came in the copyright related things was the Bern Convention, which held in the 1889, and India was signatory. India is signatory after independence, but that time also India participated in that convention on the colonial time. And in Bern Convention, two basic aspects was dealt. First thing was the national treatment. That once a copyright is protected in one country, then you need not to file a separate application in different country. So suppose Harry Potter was published in UK, but it was given copyright in United Kingdom, but no publisher in India can reproduce it because even if that copyright is not given in India, because all the IP are the local rights, intellectual property are the local rights. But in spite of that, through this convention, the national treatment is given to all the people who are even of foreign origin. And if you will file, and same happens with your work also. So if you have published something here, then globally it will be protected. So nobody can copy it, and no need for separate registration abroad. And also the suo motu registration. The moment the second part of the Bond Convention was the suo motu registration, which means that the moment work is created, then the copyright will be come into the force. You need not to go for the registration. And now special provisions for the academician. As an academician, you must know about the section 52, which talks about the fair dealing exception. Like I said, the copyright is something which gives you exclusivity, which gives you monopoly, like sir has already mentioned in his lecture. All intellectual property rights creates monopoly. So it gives you a monopoly over your creation, but at the same time it gives you gives certain exceptions as well for educational and research uses, and which includes the reproduction of research for research or private study. If you are using a copyrighted thing for the purpose of study and research, you will not be infringing it. All right, it will come within the for research or private study. If you are using a copyrighted thing for the purpose of study and research, you will not be infringing it. All right, it will come within the ambit of the fair dealing. Reproduction of if you are using that copyrighted material for in course of your teaching, then there will be no violation of copyright and there will be no infringement. If you are including some part of copyrighted material for the purpose of examination, like we all do by setting up a question paper, then there is a no infringement. In that case also you can do that, And if you are using the short extracts of criticism and review, for that purpose also fair dealing doctrine will be applicable, it will subsist. Okay, so and also for the libraries, library can create a 5 copy, photocopying can be done up to 5 copies of any book for private circulations. All right. So for librarian also, this has been made helpful. Open educational resources, which are basically uh, made open, copyright free materials. So we can, because they are copyright free and licensed for the use, then we can use also these materials for our day-to-day activity. Now, common copyright issues for academician. First and the foremost important thing comes with the plagiarism. How copyright relates with the plagiarism. So plagiarism is a ethical breach. It's an ethical issue because plagiarism is nowhere defined properly in the law. So plagiarism is an ethical issue which relates to the internal policy of the university. Some university allows certain degree of plagiarism, some university does not allow those degrees. So you are well aware of that. So plagiarism is basically the ethical breach. And the basic reason for the plagiarism is a not proper attribution. So you have to be very aware while writing any of your research, research writing, that you must attribute properly. All right. Otherwise, your book, your work will come within the purview of the plagiarism. Now, copyright infringement is a legal breach. It means unauthorized use. It means you are using it for some kind of benefit, and in totality, you are breach. It's a breach of a law. So you cannot do such things as well. But in general, plagiarism is an ethical issue. And ownership of academic work, I also want to discuss this thing, that most of the time institution and faculty researchers, they actually, there is a debate over that, who actually owns your creation. You being a part of an institution, who do have that right to exploit that your work commercially. So there is no hard and fast rule for that. Different universities, different places have got their different IPR policies on that. So that will be on the work for that. Now, thesis and dissertation. Thesis and dissertation will lie, and so I think and publication of while publishing your article in the journal, you must be aware of the IPR policy of the journal, whether you can use that material further on for your academic purposes or not. Okay, so registration is optional, like I said, but it is beneficial. Now you can use some digital online teaching related things in copyright. And I would like to mention one thing: Creative Commons licenses. You please go and explore to this website, Creative Commons organization. They provide you licensing model, standard licensing model for your work. And while creating your work, you can license it. Okay. And while publishing online, you can license it with what kind of uses, future uses you permit. Right. So now the most important thing which nowadays are AI and copyright. So although there is an ongoing debate about this issue, but still the Indian position is because India gives India recognizes the human creator, not the machine. So anything which is created by humans will be given copyright, and otherwise it will be denied from that protection. if you see the section 2B4 of the Copyright Act, for computer generated work, the person who causes the work to be created. So in a way, if you have given certain prompts which are creative enough, unique enough, then you might have the right, I mean, you might have get the copyright of that work also. Fine. So here the things are a little bit gray, not very much clear. And practical tips for the academician: always attribute sources, use license or public domain material, check institutional IP policy, consider open licensing, and retain rights if you are in a position to bargain, and document the role, your role in creation. Basically, it is for AI, upcoming AI things, that you must save all those prompts whereby you have created those AI related things, so that whenever the dispute arises, you can significantly prove your part that I have been creative enough for giving those prompts, and they are not generic prompts. It is well thought, well curated prompts, and that has led to the result in AI producing a unique thing. Okay, so now Creative Commons licensing are here. I have given there are certain category of the Creative Commons licensing. It will be very helpful for you if you are a creator, be it a digital platform or a literary platform. If you are creating something, you can assign or label your work to be shared by the way you want. Okay, so now coming to the Designs Act 2000, designs, like sir has already mentioned about the design, so many things. So I'll keep it very short and simple. Legal definition, it is basic about the aesthetic appearance, which includes shape, configuration, pattern, ornament, or composition of line and colors applied to the article. So basically, you will see the aesthetic changes that you are bringing into article. This thing will be considered as a design and solely judged by the eyes. No functionality involved. If you have made something which looks different, it qualifies for the design. You need not to go for the novelty, rigorous novelty test, like sir has said in case of patents. Okay, so it is very simple to acquire, and criteria is very not that much strict as compared to the patents. Okay, so some examples is all designs, sofa set, tea set, jewelry set, all sets. You can see here the different side, different types of bottles, different saris, even clocks, watches, everything will you look around, you will find that design into it. Okay, and here are some more examples: the dial of a watch, a goggle, a car, a Campa-Cola bottle. All these things are protected by the design. All right. So key requirements: your design has to be novel, new, original, and it should be applicable to the article, and it should have some appeal to your eyes. Okay. So it has to have that aesthetic sense into it, and it has to be non-functional. Why? Because functionality is the area of patents. So, and not contrary to the morality and public order. You cannot make certain designs which are derogatory in nature. So, these are the basic things that you have to keep in your mind. And right comfort in case of a design, once you achieve a design registration, you will have this exclusivity right. Not many rights are there: right to sell, license, assign the design, and ability to sue for the infringement primarily. The initial term is for 10 years, and it can be extended up to 5 more years. All right. So registration process is that there is a Locarno classification whereby 32 classes of articles have been created. So in that list, you will have to find out what article that you are working on. And suppose I'm going for the design of a new design of a chair. then I'll have to find that thing in the Locarno classification where chair lies. So in that class, my design will be protected. Fine. So search for novelty, that it should be novel, and filing process is there. Not much is charged for the design filing. Only 1,000 rupees is the government fee, and examined by the patent office, and it gets published in the patent and design journal. Okay, so it amounts to a publication also. All right, so that's why it is good thing for academician also. And limitation to remember, it does not protect your functionality. If the functionality is some kind of functionality is there associated with your design, go for the patent. Okay. If the patent is denied, then maybe or the patent is not possible, then maybe you can go for the design. And the registration is territorial. It is not like copyright that you enjoy the universal protection. All right. So in case of a design, if it is filed in India, you can enjoy these rights in the India. And if you want to get protection in some other countries, you will have to file there. All right. And it must be applied on a finished article, and all these things that you will have to keep in your mind. Design example, iPhone, the entire layout of the iPhone was protected by the design. It was in 2008, application number was given, it is protected by the Apple. So one product can have many IP. To conclude this session, I would like to say one product may have many IP. Like you can say, there is a patent associated with your laptop. There is a trademark associated with your laptop. There is a design associated with your laptop. And also a copyright in the form of softwares and also its literature. All right. So, like sir has already mentioned, their brother sir has already mentioned that we both are working very meticulously with the IPR cell, and anything regarding the design and any IP for that matter, it will be welcome. So the floor is open for the questions.
Okay, sir. Now, see,
gone through this, but as I'm not a core IPR analyst in this field, then but one thing I want to know, in 2023 there was a judgment given by Delhi High Court on personality right, where the right of various celebrities, like for example, the case was filed by Anil Kapoor, the Bollywood actor, that his voice, his mannerism, everything is going to be copied and it is going to be produced in various advertisements or business purposes, and various other actors also they are using it. So on that basis, he is asking the protection of that, and also because as you have mentioned about the inclusion of artificial intelligence in copyright, so whether for protection of personality right, any law is going to be implemented new, or it is going to be the amendments are going to take place in case of Copyright Act? What is the what is the recent status, sir? I just want to. Thank you.
A very pertinent question, but I do not have that answer right now. Because whether the law is coming in the future, it is still not within the purview of my knowledge so far. But I think there must be some laws related with such kind of like seeing in the entertainment industry, lot many people are copying each other, and in sometimes not for the financial gain, I would say, the copying is so derogatory. Okay, mimicry is sometimes derogatory as well, and touching upon the personal space of individual. So that way, I would say there must be some laws, not to gain financially, but to regulate it in a better manner. Thank you.
Before going to our next question, I will advise online participant to give the feedback, and from the feedback we'll issue the certificate. From there we'll take the name, spelling, affiliation details. So feedback for online participant is compulsory, and for the offline participant, we have your registration data. So by tomorrow morning we'll send you the feedback link. And through this feedback link with your proper name, spelling, and affiliation, please you submit your feedback. Now moving to our next question, one online participant from Mizoram have asked one question, Mr. Ojit Karke. His question is, how long do patent usually last for?
So once the patent is done, okay.
Sir, you answer. Sir, you should you answer. Sir, you answer it.
It's okay, sir. You have to mention on it.
How long do patent usually last for?
So, thank you for putting up this question. So, during my presentation, I have discussed about the classification of patent: utility patent, design patent, relating to plant varieties and all. So you see, my dear, in the state of utility patent, the term of protection continues for 20 years from the date of filing of application or from the date of priority. And in case of design patent, lesser term of protection, and the term of protection is 40 years. I hope I've been able to address your query.
Thank you, sir. Thank you very much.
Yeah. For many years. In case of design patent and utility patent, 20 years. And from the participant expectation and from my personal observation, there are some questions like what is the process of protecting creative and innovative work?
So I think you see during my presentation, that is what my presentation is all about. That you have some creative work or invention. So you see, for creative work, I think Dr. Patel have already described in his presentation. So, say for example, you have written some article or you have written a poem or something like that. So for that you have the right to get protection under the Copyright Act. Now, under the Copyright Act, registration is not compulsory. One thing that even if you are unregistered person practicing, whether it is your original work or not. If it is your original work, you qualify for getting protection in case of infringement under the Protection of Copyright Act 1999. And coming to your inventions, you see, if it is your inventive work and it is an invention which has got the registration or protection under the provisions of the Patent Act, in that case, if there is an unauthorized use of your work, you can bring an action for infringement in the district court. And if infringement is established, you are entitled to get damages as the remedy against the act of infringement. Thank you.
Next question is, what is the recent development in IPR and how they can benefit student and researcher?
So you see, so far as recent developments are concerned, there are certain challenges which are yet to be addressed. Because, say for example, with the innovation of AI, as Patel sir has already discussed that if any issue goes up, that copyright protection for AI generated works and so on. So far as like Indian law is concerned, under the Indian law, if you want to have an IP protection over your work, it must be a work created by human mind. So you see, this is one of the challenges that the present IP law is facing. So infringement and passing off are some of the developments in the recent time, which is still going on. And coming to your second part of the question, IP is very much related to your research work. So you see, even if it is your article, even if it is your thesis or something else that you have written and which is your original work, in order to get a protection of your work, IP plays a very crucial role. Intellectual property plays a very crucial role, and not only in the life of students. When you will be a professional, you will be working either as a legal professional or in any other discipline. But so far as your works are concerned, it is very much related with IPR, be it copyright, be it trademark, be it design. Sometimes it is GI might be, or sometimes it may be patent. So research and IT is very much correlated, and I can say one thing: protection of your research work is very much essential so far as protecting your interest is concerned. And here comes the significance of IT as so far as protection of your research work is concerned. Thank you.
Yeah. Next question is, what is the career opportunities in IPR? I'm repeating the question. What is the career opportunities in IPR?
So, a very important question. Perhaps I do not know who has raised up the question. So, but particularly the students of this university or anyone whatsoever. So, you see, IPR is a ever emerging domain, and in present day, various career opportunities are there so far as intellectual property is concerned. Now, very recently, I heard about the people who are graduating in computer science. After that, what they do, they either go for this 3 years LLB or doing some diploma on IPR, and thereafter they start working as an intern or as an assistant in some law firms, or after that they gain some experience and they start opening their own IP firms. So you see, trade, commerce, and industry and IP is very much connected. So you see, with the growth of trade, commerce, and industry, IP is also booming. So you can have a career in law firm. You can or run your own agency. You can be an IPR agent dealing with or an IPR attorney dealing with the filing and grant and protection of IP related works and concern. So you see, opportunities are huge. Only thing is that you have to come up and approve in the proper forum or the proper organization. So your application is required. Otherwise, I can guarantee you, if you choose IT as a profession and take it seriously, it will definitely contribute towards your professional development. Thank you.
Yeah. From my side, last question is how this session can assist in the research work.
Well, while doing your research, you must know that you must identify that which resources to go for. And once you are making any inclusion of that, you need to make it as a practice that you must cite those things, cite those resources, and this is the way. I mean, this entire session will promote the better ethical and legal practices of while doing your research. So I think knowing about copyright, knowing about how things work in relation to research and what are the cutting edge area where the new things are happening, like AI related things and the personality related things, right to personality. All these things are very important for a researcher to understand because this will help them ultimately to become a better researcher.
So with this, if there is any question from online side. Okay, from online, there is no question. And from physical participant. So if there is no question, so we'll proceed further with the program. And I request Anchor to proceed further.
Thank you, sir, for clearing our doubts. I now formally conclude this enlightening program. Now I invite Dr. Chanda Bhomik, Assistant Professor, Faculty of Law, ICFAI University Tripura, to deliver the vote of thanks and express the heartfelt gratitude to those who have contributed, making this event a success. Ma'am, please.
Good evening to everyone present here. As we conclude this enriching awareness program on intellectual property rights, I am honored to extend our collective gratitude to all who contributed to its success. First and foremost, our heartful thanks to our Vice Chancellor, Professor Dr. Biplav Halde sir, for encouraging us for all these events and for his constant support. We are grateful to our Registrar Sir Dr. A. Ranganath for his constant support for all these events. A special note of appreciation to IQAC Cell and IPR Cell for this great initiative to conduct today's awareness program on IPR. We sincerely appreciate the invaluable contribution of Dr. Dhananjay Datta Sir, Dean Research and Development, as moderator of today's program. We are grateful to our distinguished speakers, Dr. Devrata Roy Sir, Associate Professor, Faculty of Law, ICFAI University Tripura, and Dr. Deepak Prakash Pathak Sir, Assistant Professor, Faculty of Law, ICFAI University Tripura, for sharing their expertise in the field of intellectual property rights, which significantly enhance the quality of today's program. Special thanks to IT team and technical members, without whose support this program could not be completed in this nice way. Lastly, but not the least, thanks to all the attendees online, offline, faculty members, as it is your presence which added immense value to this program. Let us carry forward the knowledge which we gained today from all the entire session. So thank you all once again for being the active part of this program. Thank you.